All right, so, Mr. Morris, I'm going to place you under oath. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
Ronald Morris.
Mr. Morris,
Junior.
you, junior, correct?
Yes, sir.
All right. Mr. Morris, all right, let's talk a little bit about what you have going on here. It looks to me like we have three cases. I just read the case numbers out, and you're going to enter pleas on those and close your three cases with probation. Is that correct?
Yes, sir.
All right. Mr. Morris, your attorney, Mr. Charles, has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes, sir.
And are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
And is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time you needed to review it
Yes, sir.
and to speak with your attorney about any questions you have on it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Mr. Morris, did you have you had all the time that you need to speak with your attorney about all aspects of all of your cases?
Yes, sir.
Are you satisfied with the job he's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial on each of your cases?
Yes, sir.
And that by entering these pleas, these cases will all be closed,
Yes, sir.
and there will be no trials. Is that okay with you?
Yes, sir.
All right. Do you have any questions for me about anything before I pivot to the facts of your cases?
No, sir.
All right. Mr. Charles, starting with 20 SR 1114, do you stipulate that there's a sufficient factual basis for me to take this forgery plea from August 15th, 2018 here in Spalding County?
Yes, I do, Your Honor.
And Mr. Morris, do you want to enter a guilty plea to that specific forgery charge?
Yes, sir.
All right, Mr. Charles, back to you. Moving on to 20 SR 1115, do you stipulate to this forgery charge from, August 27th, 2018 here in Spalding County?
Yes, I do, Your Honor.
Do you wish to enter a guilty plea to that forgery charge?
Yes, sir.
All right, and then lastly, the suspended license. Have you used a NOLO on any suspended license charge in the last 5 years?
No, sir.
And you're 21 years of age or older?
Yes, sir.
All right. And do you wish to use your NOLO on this suspended license charge from February 28th of 24?
Yes, sir.
All right. I'm going to find with the two admissions of guilt on the first two cases and the request for the NOLO on the third case that there's enough for me to take all three of these pleas. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering these pleas.
Yes, sir.
I've reviewed the recommendations, and I'm going to follow them exactly the way they've been negotiated with Mr. Charles. Mr. Charles, the floor is yours if you would like it.
Your Honor, the restitution, we have two of them. He said that he will be able to pay them within 2 weeks.
Okay.
He said within 1 week, I said within 2 weeks, because he said his taxes, he's waiting on him, so he'll be able to pay them off.
Okay, that sounds great. All right, this all looks good. Okay, so Mr. Morris, do you have questions for me about anything, no matter how minor, before I start sentencing?
No, sir.
You ready?
Yes, sir.
All right, here we go. Starting with 20 SR 1114. Count one, forgery. This is the one from August 15th of 2018. I'm going to find you guilty. It's 12 months probation. 415 is your fine.
Yes, sir.
Count two is dismissed. You may work your fines off on all three cases with community service work if you wish at a rate of $10 per hour. Additionally, you will need to show a valid license to sentence enforcement, have no illegal drugs, alcohol, or hemp products, and be tested for those.
Yes, sir.
Fourth Amendment waiver, $50 per month supervision fee, and a $25 intake fee per case. So those things I just gave are going to be the same additional across each case.
Yes, sir.
All right, this case, 1114, runs consecutive to any current state court sentence, if any. It'll be a $50 public defender restitution fee for each of your three cases. You'll pay restitution in the amount of $350 to United Bank. You'll actually pay it to the clerk of court as a one-time payment, and then the clerk will get it where it needs to go, and you'll have 180 days from today to make that happen.
Yes, sir.
You have a second restitution payment of $400, which will go to every in package with the same procedures. You'll get the $400 to the clerk. They will take care of it. And then you'll show receipts for each of those two payments to sentence enforcement within 180 days.
Yes, sir.
Failure to do that and failure to work with us and make certain we know what's going on will very likely result in a warrant. Do you understand that?
Yes, sir.
All right. 20 hours of community service work. And that is everything that I have on 1114. Is that correct?
Yes, sir.
All right. Any questions so far, Mr. Morris?
No, sir.
All right. So Moving on to 1115. On 1115, this is the forgery from August 27th of 2018. I'm going to find you guilty. It's 12 months probation, 415. Count 2 is also dismissed. So now we're up to 24 months of probation. An additional $50 in restitution to Spalding County to offset the cost of your attorney. All other conditions, and any condition you don't meet in your first case moves to your second case. All right, that closes out 1115. All right, moving on to your last case. Count 1, suspended license, NOLO, 12 months, 750 is your fine. Counts 2 and 3 are dismissed. This is consecutive to 1115, giving you 36 months of supervision. However, this one may terminate the moment you've satisfied your obligations to the court. So if you do everything right, it's 24 months. If you don't do it right, you got 36.
Okay.
Or up to 36.
Yes, sir.
Again, $50 in restitution to Spalding County to offset the cost of your attorney, and all the other conditions that I've spoken about earlier carry over. I hope you are successful in getting this resolved within the 24 months. You have 30 days from today if you wish to appeal this decision. You have 12 months from today on the first 2 cases, the forgery cases, to use your habeas rights. And you have 6 months from today on that suspended license charge if you want to use your habeas rights to challenge these convictions.
Yes, sir.
Are there any questions I can answer for you about anything?
Your Honor, he's been in there since February, and to no fault of his own, we missed one of the court dates. Can you waive one of the attorney's fees for
Sure.
him?
In fact, that'll make the last case easier to close.
Right.
So-
The last case, he
Sure.
doesn't have to pay any.
All right, so I'm
attorney's fee.
taking the suspended license charge and I'm striking out line 3,
Yes,
which
thank
is
you.
the public defender fee, and I'm initialing it.
Thank you, Your Honor.
Okay. Oh.
Yes, sir.
All right, so you're going to go back to the back, but they're not going to take you back until Director Matthews can break free from here to come talk to you and give you your next set of instructions.
Yes, sir.
Because obviously you've got to go from where you're at, which is incarcerated, out, and then report, and she's going to walk you through what that looks like.
Yes, sir.
Okay. Anything else?
No, sir.
All right, if you'll step back to the back.
Okay.
All right, and that was Mr. Morris.
Yes, Your Honor, and that's concludes my case, Your Honor.
Okay, thank you very much. Great job as always.
Thank you, sir.
Kathy, what was that last case? 24 SR?
Oh, thank you.
It's 5 years old.
Yeah, I know. Okay. Okay. So I see you.
I'll touch base with y'all.
No.
No, they're done.
We don't have any
Mr. Upshaw, the floor is yours to fill us in on Quintella Daniel and her multiple cases and what we're about to do.
Sure, Judge, thanks. Based on negotiations with the state, we're gonna try to resolve the probation violation and the bond revocation motion. The VOP, excuse me, is based on, some new charges that Ms. Daniel picked up, in January, I believe, and the agreement is to revoke the balance on the VOP with a condition that she can be released, upon acceptance into a court-approved residential rehab program. We're also consenting to the bond revocation with the same condition that her bond be revoked, but she can be released upon acceptance to a residential rehab. And a quick question, mechanically, I don't know if that would be, I don't think she would have to post a new bond, the OR, or just stand on her old bond, but that's the gist, Judge.
Yeah. We'll just say the bond will be reinstated, and what Mr. Upshaw said is correct, Judge. We'll just say that if and when she finds a court-approved residential treatment facility, if they'll just communicate with my office, between Mr. Upshaw and I, we can put together a new bond, a new consent bond, releasing her to residential treatment.
Okay.
And they'll just reinstate her current bonds. She won't have to post. Did she have a bondsman on this, or do they OR these?
AOR.
Yeah, my thought is that we would do that OR and just
Yeah, that's-
put it back out, or at least just like a bond, even if we just do a,
Signature.
so.
Yeah,
I'm just, because if the
This is manageable.
treatment program could be expensive and,
Yes.
you know, so.
Yeah, I'm
Yeah,
fine
we're
with
okay
it.
with that.
Okay.
All right, what I'm doing right now is just printing my standard checkbox bond revocation hearing order. And what I'm gonna do is just, I'm just gonna check I'm just gonna initial the top line, which says the serious nature of the offenses. And which cases, is this on multiple cases, or which case exactly does this apply to? The bond revocation.
Bond revocation, Judge, would be, sorry, Dr. Coach, 24 SR 0080
Okay,
and 24 SR 0343. There's a third case that's 24 FAH 0418. But my office has not received that case in yet, so we haven't been able to file an accusation.
okay.
But we can just do the bond revocation on the first two. Because she hasn't actually, the most recent case, we can't revoke the bond on that one anyway, because there hasn't been any, she's been incarcerated since then.
Got it. All right, so, all right, Mr. Upshaw, come grab this from me, take a look at it. Obviously, it's got my horrific chicken scratchings on it. I'm so sorry, I have terrible handwriting, and that's why I type everything I can.
We have that in common.
Yes, so if you're good with that, you'll sign the bottom.
Revoking your bond on that old case, that means they take that bond away, he's in jail, but you can be released upon acceptance to rehab. Okay.
In fact, if you'll just write that on the bottom line, anywhere on there, just say, will be released upon, court-approved treatment.
No, we can figure it out.
Yes, this is exactly right. I'm just Upshaw, here's this one.
You wanna leave this back?
This is the one that goes with it, for the probation.
Okay. This is the probation order, okay? So waiving the probation here and understand that probation's gonna be revoked, okay? But you may enter court-approved inpatient treatment in lieu of serving jail time, okay? Instead of serving jail time. So a separate order will be sent to the judge to release you once a approved location is identified. Okay, that makes sense?
Yeah.
You understand?
So is he gonna say which one to take?
Well, the first thing is we're gonna figure out where we can get you accepted into, and then we're gonna present that to Ms. Mann. So,
In fact, somebody was in court the other day, somebody was in court the other day and we got all excited because it was a female residential, I don't remember what it was, I just remember getting excited.
It was last week, wasn't it? Last
your life pretty easy.
Yes. I just hate having to do them because the rates are so
I love forms, and I have a bazillion of them. The problem is,
I don't know if that's.
I don't have them all organized.
Well, you just did one on St. John's.
Yeah, that's,
So I don't know if that's system and finding one.
There's a FMV number on that.
Patrick, I'm gonna reluctantly restore McDaniel if you don't fight me.
what was Johnson's first name?
Taylor. Do you have docket number? You got it?
All right, so, I'll clean that up here in just a second. So we have three items: the vacate order, this petition for revocation, which is gonna be a consent order. and then-
Yes, sir.
All right, ready, Kathy?
And Judge, just for the record, I guess, that I got into this case and technically, by the letter of the law, I'm involved in the second of those, as far as the modification. I do not technically represent him, but as a friend of the court and solicitor's office, I explained the recommendation that has been given to him, and he's accepted that recommendation. But I've gone over with him collateral consequences to the best of my ability, reviewed his history and things of that nature. So I just wanted to be clear with you.
Yes, that he's, and I see that on here, that as to the plea, he's technically entering it as a self-represented.
Yes, sir.
But you're, I guess, at the very most, shadow counsel.
Yes, sir.
Which, is a term we've all learned, so.
Yes, sir.
Yeah,
Okay.
so what, and like Mr. Hutchinson said, this is one where the only way I was willing to agree to the issue on the probation was for it to include a plea to the new charges.
I agree. And to be fair, you came in earlier this week and we had a very extensive conversation, the three of us,
Yes, sir.
and explored potential solutions. So I appreciate the time you've already put into this case that you haven't been fully hired on, so.
Yes, sir.
Okay, so, what I'm doing now is just saving the Jennings order, and then I'm gonna move it over and fix it. Okay, so let's jump in first to the part that is yours,
Yes, sir.
which is this probation revocation matter, which is 21 SR 1253. It appears that you all have reached a consent order. Is that correct?
That's correct, Your Honor.
All right, and Mr. Shepherd, is that correct as well?
Yes, sir.
All right, and so what I'm gonna do is I'm signing that now. Ask the bailiffs to just make 2 copies, give the original back to Director Matthews and the 2 copies to them.
Thank you.
Mr. Jennings, I'm gonna step over to the part where you're self-represented, okay?
Yes, sir.
And Mr. Hutchison is here to quietly answer questions off record at this point forward. But he's not gonna speak for you on this 22 SR 2066 case. Do you understand that?
Yes.
Excellent. Mr. Jennings, raise your right hand for me. That's all you need. Do you solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Mr. Jennings, you are here on 22 SR 2066, and you have a couple of different moving parts. But on this one, you're wanting to enter a guilty plea and close this new case. Is that correct?
Yes, sir.
All right. So on this case, I'm holding up this self-represented defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yeah,
All
I
right.
recognize you.
Yeah, and are these your initials next to each of the lines on page 1?
Yes, sir.
Page 2?
I initialed all of that, sir.
Yes. And is that your signature?
Yes, sir.
All right. And did you sign and initial this document after having all the time you needed to review it?
Yes, sir.
And although Mr. Hutchison is not representing you on this as a friend of the court, he was standing there. And did you have a chance to ask him any questions you have about it?
Yes, sir. You talked to him about it.
Perfect. And do you have any questions that I can answer for you about anything on this document?
No, sir.
And do you understand that you are technically here without an attorney, and that if you asked for more time to see about hiring them fully and bringing them in to represent you, I'd give you that time? Do you understand? If you wanted that, it's available to you.
Yes.
And do you want to go forward today as you are at this little piece for representing yourself?
Yes.
Okay. Mr. Jennings, you also have the right to a jury trial, and by entering this plea, there will be no trial. This case will be closed. Is that what you want to do?
Yes, sir.
All right. Now, Mr. Jennings, we had a lot of confusion this week trying to figure out who you were. Will you do me a favor and state your first, middle, last, and then spell each of those so that we can make sure it's correct in our system?
Stephen Charles Jennings, Stephen Charles, Charles Jennings.
Jennings. And Jennings.
Yes, sir.
Got it. Okay. All right. So it's PH, not a V.
Yep, my first name's Phen.
Okay, perfect. It was a couple of different ways in our system, so. All right, so Mr. Jennings, moving forward then, on 22 SR 2066, you're charged with one count of criminal trespass. And that you did here in Spalding County back on March 5th of 2022, damaged the property of Lisa, looks like, how do you pronounce her last name? Gurianis? Is that someone you know?
Gorganus?
Gerganus.
Yeah, she was my girlfriend.
Okay, so you did damage the property of Lisa Gerganus without her permission. Did you do that?
What now? What's that?
He's asking if you did the crime that is alleged, the criminal trespass.
Well, I'm pleading guilty to it, sir.
Okay, I'm gonna mark this as a best interest plea.
Thank you, Judge.
That'll keep us on track, so. All right, Mr. Jennings, do you wish to enter a guilty plea to this criminal trespass plea not because you think you did it, but because you think that, given the entire picture of what you got going on, you think this is in your best interest? You think entering this
Yes,
plea
it's
is
in my best interest.
Yes, is that what you want to do?
Yes, sir.
Okay, good. Then, do you want to enter a best interest plea to count 4, the reckless driving charge? No, that's a NOLO. Do you want to enter a NOLO to that charge, the reckless driving charge?
Yes, sir.
And do you want to enter a NOLO to the suspended registration charge, count 5?
Yes, sir.
Great. I'm going to find with the best interest plea on count 1 and the NOLO pleas on counts 4 and 5 that there's enough for me to take your plea. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering this plea. I reviewed the recommendation and I'll follow it as it's been negotiated. I know you're not here officially, but do
Yes,
you have anything you want me to know since this all factors together?
Judge, yeah, I think this has been one of those that with probation, the state, me, the court, and Stephen, we've tried to work things out and tried to sidestep all the landmines that we can. Stephen's got a significant history. He understands, he is not supposed to be driving until he's got a valid driver's license. He knows he's not supposed to be hanging out with Lisa Gaines anymore. He knows that he's supposed to be reporting to probation as directed. There's some conditions of his probation that he still has to do as far as substance abuse evaluations and follow recommended treatment. He's promised me that this is something that he's going to take serious from now on. He does have some concerns about transportation to probation, but his sister has basically indicated that she'll make sure that he gets where he needs to get when he needs to get there. I'm concerned as far as his counsel that I may be setting him up for failure, but he has convinced me as his counsel that this is something that he can do and that he is going to do. And with that assurance, we're entering this plea and we're entering that consent. But I'd be lying if I told you I didn't have some reservations. But he's made a believer out of me, and I'm willing to go along with him.
All right. And, we've all been in this line of work a long time, and we all have moments where we just kind of see if we can help somebody through it. So,
Yes, sir.
all right, you make this work, okay, Mr. Jennings?
Yes, I'm unable to drive anymore medically, so I can't, anyway, so
All right.
I can't never drive again.
All right. Well, if you do drive again and you get caught, it's going to be really bad for you.
I can't drive.
Well, I know,
medically
I'm
can't.
saying you don't have a license, but I'm saying if you get behind a wheel and get caught, you and I are going to get crossways real
yes, sir.
quick. Okay. Are you ready, Mr. Jennings?
Yes, sir.
All right. Count 1, criminal trespass, best interest pleas granted, guilty, 12 months, 590 is your fine. Count 4, reckless driving, the NOLO is granted, it's 12 months consecutive, 557.50 is your fine. Count 5, suspended registration, NOLO, 12 months concurrent, 449.50 is your fine. Counts 2 and 3 are dismissed. That's 24 months of probation, no jail time. Are you planning on trying to get a driver's license
No, sir.
reinstated?
I might not be able to drive anymore.
All right, then I'm removing the license requirement and I'm gonna place at the bottom, surrender driver's license. Is that correct?
Yes, sir.
All right, this is consecutive to 21 SR 1253, which will give you a little bit of time to get everything sorted out. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee, 20 hours community service work, and no contact whatsoever with Ms. Gurgianis. All right, and that closes out 22 SR 2066. All right, Mr. Hutchison, anything else on
No,
this
Your Honor.
case?
No, Your Honor.
All right.
I do have a couple questions I need to ask Marty, but.
All right, Mr. Jennings, do you have any questions for me?
No, sir.
Yeah.
If I was to come up somehow with some money to pay it, some of this off, could some of it be dropped? The
Well-
second part of it.
As far as the charges go, no. What the charges that I've just announced you're pleading to versus getting dismissed, they stay as they are. But if you are able to get your obligation satisfied, your reporting requirements will get better. They always do. So you should absolutely do that.
Okay, yes,
So,
sir.
all right, let me pivot over to the order. I've got it half typed out. I have Stephen Charles Jennings, 22 SR 2060. No, the one I need to do the order in is
1253, I think, Judge.
Yes.
Let's go off record.
I'm so, that's 21 SR.
21 SR 1253.
Yes, sir.
And we're just vacating the banishment.
That's correct, Your Honor.
Are we okay with just vacating the whole order that got signed? so
That's
we can-
easier. Yeah,
So we
that's,
did a new order today?
Yeah, then just put in a new order, yeah.
that's
Yeah,
great.
versus,
Let's
that way
just
we
do
don't have to
that.
worry about pieces of it.
I love this idea. So
That's fine.
that is a much easier order to type than what I was trying to do.
Do you need to know the date that that order was signed?
Yes,
Judge?
please. Or filed.
Um,
I have it right here.
I probably don't have
I have it. Right here.
e-filed.
We're good. I've got it right here.
Hey, Piper, can he have this? Take it back.
Can't have anything that's legal.
Oh,
All right, is that the 3/14/24? That's the one that says, it doesn't say banishment, it says like leave.
I wouldn't about that.
County.
Not worry about
Yes,
that.
sir.
Go.
That's
Okay, got it. Okay.
That's one of the questions. Yeah, it's either gonna be something.
We have multiple people that don't understand what banishment means, so we
Put leave.
leave.
That's what they said. Was that mean I can just, go to the county line, cross it, come back?
Key last spot.
I guess it needs to technically say leave and don't come back.
Leave and don't come back.
All right, I'm printing that, I'm gonna attach it to this one, and then we'll be done, right?
Yes, sir.
Am I able to get a signed copy?
Mhm.
Couldn't get away with it, I don't think.
Okay, instructions, take a look at this and see if that's right. So I'm gonna attach this as exhibit A, because that's the 314. You may go back to the back. Paper copies of everything will be following you back in just a minute.
Yeah.
All right. All right, Mr. Moody, you ready on yours? Is that his?
That's it.
Okay. All right, so, no? Good morning. Oh, yeah. Yeah, Morris. I mean, you're welcome to do it too. That's why it's out there in the open. There it is, Cornelius McDaniel. Consent. Okay, Kathy, I just signed a consent order on McDaniel on page 2 at the bottom. And that was gonna be another one of the big hearings. I don't need McDaniel, I need Barry.
I'm working on it.
And your desk up here, as you're well aware, is twice as big as the one upstairs. It's still not enough space.
I'm gonna.
All right, let's come back to order. I'm gonna handle the plea on Jerry. Is it Barry, sir?
Yes, sir.
All right, I'm gonna place you under oath. You ready?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down. State your full name for me.
Jared Martini Beard.
Mr. Barry, you're here on 2 cases, I believe. Yes. 24 SR 0306 and 0307.
Yes, sir.
Your attorney has worked out a plea. Is that what you want me to take?
Yes, sir.
All right. Your attorney, Mr. Moody, has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document that I'm holding up?
Yes, sir.
And are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it
Yes, sir.
and to ask your attorney any questions you had about it,
Yes, sir.
and because you understood everything that's on it?
Yes, sir.
Are there any questions I can answer for you about anything on this document?
No, sir. Thank you.
Mr. Barry, did you see on here that you have the right to have, I'm so sorry, that you have the right to talk to your attorney? Have you had all the time that you need to talk to your attorney about all aspects of both of your cases?
Yes, sir.
Are you satisfied with the job he's done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial on each of your cases?
Yes, sir.
And that by entering these pleas, there will be no trial, and these cases will be closed? Is that what you want to do?
Yes, sir.
All right. Mr. Barry, do you have any questions for me about anything on this attorney and defendant plea rights waiver or anything else before I pivot to your attorney with my next set of questions?
No, sir.
All right. So, are these concurrent?
Yes,
Okay. So it doesn't matter. I'll just do them numerically then.
concurrent and credit for time served, time deemed served.
Thank you for that. And, okay, I've marked both of those. Thank you for that. All right. So, Mr. Barry, I'm so sorry. Over to you, Mr. Moody. Do you stipulate that there's a factual basis to support in 24 SR 0306 this shoplifting charge from October 21st, 2023 here in Spalding County?
Yes, sir.
Do you wish to enter a guilty plea to that shoplifting charge?
Yes, sir.
Mr. Moody, over to the 0307, do you stipulate there's factual basis for the obstruction charge from 11/1/23 here in Spalding County?
Yes, sir.
Do you wish to enter a guilty plea to that obstruction charge?
Yes, sir.
All right, I'm going to find with your attorney's stipulation as to the factual bases on each of these cases, combined with your request to enter guilty pleas, that there's enough for me to take these pleas. I'm going to find that you're knowingly, voluntarily, and intelligently waiving your rights and entering these pleas. I've reviewed the recommendations, and I'll follow them exactly the way that they've been negotiated. Mr. Moody, the floor is yours if you wish to add anything on the record.
Your Honor, we just asked you to accept the pleas negotiated. Mr. Berry has been in custody now at this point, the equivalent of 6 months. He had a BOP upstairs, that imposed a sentence, and instead of trying to fight these cases, after the BOP, he wanted to resolve these, and I'd ask that you just accept what's been negotiated.
Okay, and I will.
Thank you.
Mr. Barry, do you have any questions for me before I sentence?
No, sir.
All right, here we go. Jerry Berry on 24 SR 0306, count one shoplifting. That's from October 21st, 2023. I'm gonna find you guilty. It's 6 months to serve. There's no fine, no probation, and no probation conditions. You will receive credit for all the time that you served, which I believe this is a time served in full. Is that correct?
Yes.
All right, you will receive time served in full credit, and I've initialed that line. I do need to notify you that on 24 SR 0306, that because this is a shoplifting and you are represented by counsel, that this could be used against you in any future shoplifting prosecutions for aggravation of punishment. Do you understand that? All right, moving on to the obstruction, 24 SR 0307. Obstruction, guilty, 6 months to serve. No probation, no probation conditions, credit for time served in full, making this one also a time served plea. Now you've entered 2 time served pleas. As you do not need to meet with the probation office, sentence enforcement team, the bailiffs are going to take your final decision, pull it apart, give you a copy to take with you. I don't know what else has a hold on you, but these holds will be lifted. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you want to use your habeas rights. Now, Mr. Barry, any questions before you and I part ways?
Oh, thank you, sir.
All right, Mr. Moody, anything else?
Yes, sir.
I think that's everything you have, right?
It is.
Great to see you as always.
Just
So,
well done.
Jerry, do you have anything else?
all right, and then Mr. Moody's other case, McDaniel, they presented me with a consent order and I signed it.
Same with Mr. Ogletree?
Yes, I signed Ogle. Is that was Moody's as well?
Yes, sir.
Okay, I didn't catch that. All right, so Mr. Moody's Ogletree case, Mr. Ogletree's case was also consent, and I've already signed it. Okay, great job, y'all. What else are y'all here on?
Most of the calendar.
Yeah, okay.
We had a big one today. Judge, we do have, let's see, the witnesses here on Mr. Hogan. We have a motion or a vote.
Okay.
Officer Billings is here. If you're just like, I know we didn't need to call the count. Will we call the calendar yet?
No,
I've
no.
been coming and
I
going.
jumped in and got the private attorneys out of here, and then I was gonna call the calendar. Well, look, why don't I just call the calendar, as soon as Director Matthews gets back in, and then I'll ask for recommendations as to what order to call things.
Yes.
So let's come back to order. Mr. Shepherd, do you have a recommendation to me as to which of these bond revocation motions you'd like me to hear first?
So Judge, since we have Officer Billings here on Mr. Hogan, we'd ask that we do that one first.
Okay. And I will just simply say that what we'll do as far as the witness seat goes, let's just move the witness down in front of Kathy on the table down there, since Director Matthews' stuff is spread all throughout here. So if y'all will just pull a chair up and, does that work for you, Kathy?
Absolutely.
I got, no.
I gotta tell you, I'm the luckiest judge in Georgia. I don't have to worry about anything. Every time I go, I have a good idea. It's either a bad idea that you talked me out of it, or a good idea you've already taken care of.
End up like 20 minutes, y'all take care of this.
Yeah, y'all. Never happened.
All right, well, the good news is I'm about to do a hearing we don't need you on, so that helps you a little bit. Miss Tony, which one was it again?
Hogan.
Hogan. Mr. Hogan? Oh, well. Is it? I haven't called the calendar yet. That might be why we have that answer. But I thought Hogan was here. I thought he checked in. Hogan, last chance. I wasn't, okay. Well, I tell you what, I'm gonna set a timer on my phone.
It's about to be real quick, man.
Because you got 3 minutes, then I'm gonna cut you loose. Because
I'm gonna go check.
I had a note that he was
I don't
here.
have him checked in. You don't have him checked in?
You don't? Well, I might have had the wrong,
Yeah, I thought they said
Hollis
no.
was here. Maybe that's who I have. Is Hollis here? Hollis? Okay, there's somebody out in the hallway saying they're here.
He was OR'd out. Hey, Judge, he's been picked up 10 times since, 10 different arrests since the original bond was issued.
Goodness.
Yeah, so that's why we filed this. I mean,
Sure.
It's just ridiculous. I was under the impression, I thought somebody told me he was here.
Yeah, I did too. So, but again, I didn't call the calendar like I normally do when I first sit down because we were trying to get everybody out the door. So,
Let me check the jail record.
He's not on the census.
He's not.
No, just checking.
okay, well, he's got one more minute before I'm going to issue the warrant. So, and that's going to make your life a lot simpler and y'all's lives a lot simpler because we're about to have a hearing. So, okay, well, let's just see. Let's just make sure he didn't, I don't know,
I didn't have him checked in.
find a, okay. All right. Y'all have other motions to revoke bond that need to be heard this morning?
Christy Dobson.
Is Dobson here?
Right here.
Okay, she's waving at me, so she's here.
Deputy Williamson is on that case. He is upstairs in Superior Court, so we can grab him. But if you want to go through the calendar, we can let him know.
Yeah. Okay, time's up on Hogan. So, all right, so let's just put this on the record. On Sean Hogan, it's currently 10:38. I obviously mistakenly, thought he was here. Solicitor's office thought he was here, but the bailiffs are telling us they never checked him in and never marked him as here. So obviously, we just had a moment. So I did not call the calendar when I first sat down, and this is kind of what happens when we do that. And so, lesson learned on my end. So I'm sorry that you are sitting here waiting on somebody that only half of us thought was here. But either way, Sean Hogan is not present. This is a motion to revoke bond. He was ordered to be here today. He is not here. Does the state have a motion?
Yes, Your Honor, we request a bench warrant.
All right, that is a bench warrant that is issued. It's granted. I'll mark it as no bond, so he can't get back out. And you may release your witnesses. All right, again, officer, sorry about that. That's on me, nobody else. All right,
Just to confirm what Patrick's already said, he's not showing being ill.
okay.
Are you scared of him?
That's on my end. All right, well, let's talk to Ms. Dobson just a minute before you pull your witness out of Superior Court. So, Ms. Dobson, come on up. I'm just gonna talk to her for a second. Ms. Dobson, if you'll move over to that seat there. Actually, if you'll come to the podium, because there's a microphone. Ms. Thompson, you are here today because the state of Georgia has filed a motion for me to hear. This motion is that they would like for me, if I do what they want me to do, to revoke your bond and place you in the Spalding County Jail until your case is resolved. Do you understand what they're asking me to do today?
I understand what you just said.
Okay, and obviously I haven't made a decision yet. That's what we're here to sort out. And obviously, if I do what you want me to do, then I would I would deny their motion and I would leave you out on bond as we are. So those are the two possible outcomes of what we're about to do. So we have two pathways forward and you get to choose the pathway. So do you understand that the next decision is yours to make?
Yes, sir. I
All
understand
right.
what you just said again.
So the pathway forward, there's two pathways. The first pathway is we go forward with the hearing. They have a witness here. They're telling me the witness is upstairs in Superior Court. They'll pull him downstairs. We'll start your hearing. And then I will make a decision. And it's by the scales of justice you can see. I always point over there, but that's the arch. It's not the scales. But the scales of justice for the purpose of this hearing, if this was a criminal trial, the scales would look like this, beyond a reasonable doubt. It's the highest standard under the law. But to make a bond decision, the scales of justice is by preponderance of the evidence. So it's literally 50.1% in either direction. So I'm just letting you know that the burden on the state to prove the bond issues is much lower than a criminal trial. It's much easier for them to prove than a criminal trial. Do you understand that that's just the standard under the law? Does that make sense?
I really didn't understand all of that.
Let me try that again.
I'm listening though.
I
It
can-
makes sense, but as far as my acknowledgement, no, sir, I did not understand.
How about
all of
this?
that.
It's much easier for them to convince me to revoke your bond at this hearing than it would for them to convince me to find you guilty at a bench trial.
Yes, sir.
How about, does that ease? So obviously I wouldn't use that analogy, but I'm trying to really pull it to a place where I feel like you and I could connect. So, okay, that's my first option is we just jump into the hearing. The second option is you can talk to them for a minute if you want. You're under no obligation to talk to them and you can certainly say no. And if you can work out an agreement on what happens next on your case that both sides agree to, you can present that agreement to me and see if I will take it. That agreement may involve you not going to the jail. It may involve you going to the jail. I don't know. It's y'all's agreement. I have nothing to do with it. So do you want me to call this hearing and start it? Or do you want to talk to the state for a minute and see if you want to resolve your case?
I would just like you to proceed.
Okay, then grab a seat in that chair right there. We will, well, you know what, Mark, let's, no, you have too many things. Let's just give you this one. Oh, sorry.
Do we need to get Williams?
Yes, but I thought we would just call the calendar. I'm gonna leave her there. Yeah, that's fine. And I thought what we would do is just call the calendar now that, Martin's back. And again, we were intentionally doing things like this. Yeah. All right, everybody, let's come to order. We're going to officially call the calendar at this point.
I do. Haven't put any out.
Oh, that's okay. All right, as I call your name, if you were here today, and again, it's 10:43. We normally call this calendar about 9:30 or so. This caused a little bit of confusion this morning. Again, that's completely my fault. I apologize. But we're going to call it now, figure out who's here, who's not, and get organized. As far as, I will say really quick, on the Hogan matter that I just called, where he was not here, I have now officially signed his bench warrants, and they are marked as no bond. So those warrants are officially signed and on the books.
Either way.
Yes, it's an easy solution. All right, as I call your name, if you're here for probation, answer here. If you're here for something else, tell me what you're here for. All right, Lorena Asensio? Asensio?
Is that probation or your
That's a pretrial.
we'd ask for a bench warrant be issued.
Granted. All right, so that's a warrant. Alvin Capps.
Here.
Thank you. Caps is here. Lester Chambliss.
That case is off, Judge.
Wonderful. Thank you. All right. Kusan as a consent order. I signed it this morning. Quintella Daniel as a consent order. I signed it this morning. Jerry Berry was a plea. I handled those pleas on the two write-ins this morning, and that closes out page 1. That brings me to Christy Dobson, who is here. We're waiting for the witness to come downstairs. And then Pernell Evans. All right, thank you, Mr. Evans. Sit tight. Previously, I called Sean Hogan, which was a motion to revoke bond that the state filed. He did not appear. I issued 2 warrants. I've signed those. They're ready to go. Adrian Hollis.
That case is off, Judge.
Wonderful. All right, Cornelius McDaniel was Mr. Moody. He was here earlier. It was a consent order. We finished that up. Stephen Jennings, 22 SR 2066. I think this one was the plea. Or was this one the?
66 was the plea.
Okay. Okay, so that takes care of Daniel and Jennings and page 2. Anybody need anything on page 2? We're good to go. All right, Milner Pickens. Milner Pickens, it's an interlock request? No? All right, so I'm gonna recall that at the end of the calendar. If they're not here, it'll be denied, and they have leave to refile.
State last that you deny it based on lack of prosecution.
Yeah, that's granted. If they walk in, I'll withdraw that and we'll hear it. So, but it is, I'm gonna write on, you know what, I'm gonna go ahead and rule. I'm gonna rule, because I'm thinking it's the morning, but it's already 10:47. So I'm writing no show, and the motion is denied for lack of prosecution. Done. Do y'all need me to issue an order on that?
No.
Okay, I just want to make certain that everybody has what they need.
Absent an order, nothing's gonna change
No.
with their license, so I don't think
Okay, then everybody's good. I just realized I've been meaning to ask y'all that. Jarius Mitchell. Perfect, thank you. All right, Frederikus Ogletree was one of my big hearings today. It was Moody, consent order, and it was signed. Steve Presley. Steve Presley.
He's in jail, Judge, on a VOP, and I don't think they brought him.
Yeah, so Judge, we filed this motion to revoke based on the new charges. He also had a VOP running parallel with it. He signed the consent on the VOP. So since he's where we want him.
Okay.
We'll just withdraw it.
Okay, so if you'll just file a withdrawal of that, I'm gonna put withdrawn by state. All right, and I'm gonna mark it off altogether.
Erica, can you put that on will you put those 4 cases on a jail count? How long does that be the consent for?
214.
214. You signed that this week, right?
Pretty recently. I do think he may have more cases in my office already sentenced.
Okay.
So I don't know if you want to chat before you get to that date.
Right. If you'll put it on a jail calendar, take that mid-May. If you'll add him.
I think he has one more case after the one that just got revoked. But I'll get you an answer by the end of court.
Okay, thank you. I just want to get to when he's releasing the VOP.
Do May 8th or May 15th, but again, I don't have a preference on any of that. So.
The 15th would be during that arraignment week, so do the 15th, please.
That'll work.
That'll be a smaller day, so we can add these 4 cases.
That'll
Yes,
work.
sir. He just signed to serve 214 on 21 SR 0819. And then he has another consecutive case, 21 SR 0820, that he's already been sentenced on, that is a banishment.
All right.
his sentences is only showing one probation violation. I guess it's this one.
Yeah, so if he gets out, we'll just have him come back in. So if you don't want to withdraw it. If we just want to leave it until the 15th, that's fine with me.
That's what I was kind of thinking.
Yeah, that's fine. And since we have a definitive date now, instead of just a general something out there, I'm okay with you not withdrawing it, because we'll address it on the 15th. So. Okay. Nakira Smith?
In the hallway with the child.
Okay.
Is that a 30 for 30?
So,
Yes, sir.
okay. Makeba Thorpe? All right. And how do you say your first name? Makeba. Names are important. I want to make sure I get them right. So, all right, that's page 4. And then, just to say it out loud, we had a couple of jail cases that were added. We had Ronald Morris Jr., who was here with Jukes Law Firm earlier. He pled on 20 SR 1114, 1115, and 24 SR 425. We also had someone named Kemp, first name I didn't catch, also with Jukes. It was a plea and absentia on all 3 cases for time served. And those were 22 SR 599, 600, and 601. Those are closed. I signed those this morning. They had everybody's signatures on it. So
I don't remember that one, but
they had it in their bag. So they said, while we're here and you're here, will you sign these? And I'll say out loud, we did the plea in absentia where we're doing now with the final disposition on the front. I really like that. And I want us to start doing that with the final dispositions on the front so that we don't have to guess at what the sentence actually is. So, okay. Anybody out there whose name was not called? Anyone out there whose name was not called? Okay. Are there any inmates whose name I didn't call?
On the last page from
Thank you.
yesterday's calendar.
Okay.
Patrick, Presley's set down to be released on July 21st.
Charles Sturgill, I've sent you an unmute request. If you'll approve that, please.
Yes, sir.
All right, Mr. Sturgill, I apologize for not being able to address you virtually yesterday. I was not available yesterday. And there we are. So you're officially a bench warrant. I'm actually going to lift that as if it was never there, because you did log in. You just weren't able to be brought in. So you and I are good. Mr. Sturgill, you have 4 options this morning. Do you want me to just reset him, or do you want to talk to him?
I don't know if we're going to be able to get to him this morning.
That's fine.
I've
All
got
right.
one more after when Jackie's doing.
Oh, yeah. So, Mr. Sturgill, what I can do for you is, are you wanting to get an attorney to represent you on this, or you just want me to move you over to a calendar? What do you want to do?
I'm currently seeking legal representation.
Perfect. That sounds great. Grab a pen and a piece of paper, and I'm about to give you some information. Tell me when you're ready.
Okay, I'm ready.
Okay. So what's going to happen is I'm about to reset you for a trial calendar. Between here and there, you're going to reach out to the public defender's office to see about having them represent you, or of course, hire your own attorney. Do you understand that so far?
Yes, sir, I do.
Now, why are you virtual here today? I don't remember.
I'm currently at work.
Okay. What is that? I'm at work too. What does that mean?
I just seen on your website where if it's an arraignment, we were welcome to be virtual.
Okay. I tell you what, when you come to your next court date, I do need you to appear in person.
Yes, sir.
So virtual, you know what, it probably does say that from COVID. I need to get that fixed. So yeah, from this moment forward, you're going to need to appear in person unless you get permission.
Yes, Your Honor.
Okay. All right. Your next court date where you and I are going to see each other in person is going to be Tuesday, August 27th, 2/7 at 9 a.m. sharp. Do what? Oh, Wednesday the 28th. I might be off. 27th of Tuesday. It's all right. It's still an arraignment day. I mean, a bond counter call day. All three of those are bond counter calls, 26th, 27th, and 28th. And if you've been giving folks Wednesday at 9, just tell them right now. This is an easy fix. I'm all about that. Okay, so it's Tuesday, August 27th at 9 a.m. You're going to be here in person, not virtual. That's your calendar call. If you do not resolve your case at that calendar call, you will appear for your jury trial, or your trial, the week of September 9th, each day at 9 a.m. until your case is closed.
Yes, sir.
All right, so what is a good phone number for us to reach you if we need to reach you?
470-815-8455.
What is your birth year? Not the whole thing, just the year.
1990.
And what is the last four of your social? Not the whole thing, just the last four.
4510.
Do you understand if you miss any of these court dates I've given you? I'm so sorry. Do you understand this is the only notice you'll receive of these court dates?
Yes, sir, I do.
You understand if you miss these court dates, I'm going to issue a warrant for your arrest?
Yes, sir.
You understand it's your responsibility to take immediate action to secure the public defender's office. And if you don't do so, that is your responsibility and you'll have to reap the benefits of, the consequences of it.
Fully understood.
Their phone number is 678-688-8296. If you go to spaldingcounty.com, go to the state court page, you will find their contact information as well. You can also navigate there and find information about your case, including these dates. Do you understand that?
Yes, sir.
Do you have any questions for me about anything before you and I part ways?
No, Your Honor.
All right. Then I will see you here in this courtroom, not virtual, on August 27th, 2024 at 9 a.m.
Yes, sir. Thank you.
It still says that. I thought we'd fix
That's
that.
just a
All right.
relative
Thanks,
code.
Mr. Sturgill.
Thank you.
That explains why we keep having folks show up All right, Mr. Evans, please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
I'll take your hand down. I'm also going to take a moment and swear Director Matthews on all testimony for today. So Director Matthews, if you'll raise your right hand on all cases. You solemnly swear or affirm that all testimony you will give on all matters today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, take your hand down. All right, Mr. Evans, what we're about to do is I've got you're here today because your sentence enforcement supervisors filed paperwork with me alleging that you're out of compliance with your probation. Do you understand that's the question on the table today?
Yes.
Do you understand that you have the right to have an attorney represent you and you're here representing yourself?
Oh, yes, sir.
Okay, and is that what you want to do?
Yes, sir.
All right, you ready to go forward?
Yes, sir.
Okay. Director Matthews, floor is yours.
Judge, I've asked Mr. Shepherd to assist with this case as I have documents that I need to tender, so I don't know if we need to change our procedure
Sure.
at all.
Ms. Shepherd, floor is yours.
Sure. All right, Ms. Matthews, you've been previously sworn, correct?
Yes, sir.
All right. Can you state your name, please?
Marty Matthews.
And Ms. Matthews, how are you employed?
I'm the director of the Spalding County Sentence Enforcement Office.
And so are you one of the probation officers for Mr. Purnell Evans?
Yes.
Is that Mr. Evans standing here to my right?
Yes.
Okay. All right. And when was he placed on probation?
On this case, he was placed on probation on January 18th of 2023.
All right. And what was the charge in this case, the 22 SR 635?
A suspended license.
All right. And is there a consecutive case?
Yes, sir. It's 22 SR 637.
All right. And what's the charge on that?
Bear with me 1 second.
Battery, family violence, sound correct?
That does sound correct, yes, sir.
Now, is it a 24-month total sentence between the two?
Yes. The suspended license is no early termination. He does have a non-report option on the battery case.
All right. So how much time does he have remaining on the 22 SR 635?
He has 267 days remaining today.
All right. And then the full 365 on the consecutive case?
That's correct.
All right. Now, you filed a petition to revoke his probation?
That's correct.
And what's the basis for the probation revocation?
Mr. Evans has been on probation with JAG and now my office for many years. He's got a condition to do community service. He converted his fine, and he needs to do that at a rate of 6 hours per week. And he's currently should have done 48 hours, and he has turned in 6.5. And he's also on zero tolerance from a previous case. And I continue to have issues with Mr. Evans in all aspects as it relates to community service. I have some documents that I'd like to tender for the court. One of those.
All right, let Mr.
Do
Shepherd.
you want both of them?
Yeah. Is this the only copy of that?
That's the only copy I brought.
Yes, can I make a copy?
Yes, of course. It's okay.
You mind too, so.
We had a lot of moving parts today. While they're doing that, on a housekeeping matter, Mr. Evans, I have you as Purnell, Pernell. Is that the correct spelling of your first name?
Yes, sir.
And your middle name is Lewis, Lewis?
Yes, sir.
And then you're senior.
Yes.
What is your birthday?
5/10/1964.
Okay. And then I have a junior. Is that, I assume that's your son?
Yes.
And is his spelling exactly like yours? Purnell Lewis Evans Jr.?
No. It's PENN.
So he's Purnell, Pennell?
Yeah.
But he's still junior?
Yes.
Okay. That explains why I'm confused. So. Pennell is your son.
Yes.
Lewis, Lewis.
Yes.
Evans, Jr.
Yes.
All right, I'm adding that as an also known as so that we can try to keep you two, because y'all's names are kind of all over the place, over each other.
Yeah.
All right, Ms. Shepherd, floor is yours.
All right, thank you, Judge. All right, Ms. Matthews, so we've got a couple documents here in front of you.
Yes, sir.
All right, do you recognize what those documents are?
Yes, sir.
What are those?
So one of them is a community service log that we provide to the defendants, that has their name, their charges, their officer, how many hours they have to do, the rate they have to do it, and then when they go to an approved location, the facility or the organization documents their hours, the time, and then they sign off on it. The defendant then turns this into us to receive credit.
Okay, so we'll call that State's Exhibit A, community service log.
Yes, sir.
Now, is that a true and accurate copy of the document that y'all have in your office for Mr. Evans' case?
Yes, sir.
All right, and so is this one that Mr. Evans himself would turn in?
Yes, sir.
All right, we'll tender this as State's Exhibit A.
All right, Mr. Evans, do you have any objection to me using this document that you have a copy of at your table and making my decision on your case?
No.
Okay, then it's tendered and admitted without objection.
Okay, and then the second document that I've handed you, we'll call that State's Exhibit B. Ms. Matthews, what is that?
This is, he turned this into our office on April the 3rd. We have a community service opportunity where people can choose to purchase donations and turn those in with a receipt of those donations only. Those are the instructions that the defendants provided. Mr. Evans turned this into us stating that this was his receipt because he lost his receipt.
Okay, is that a true and accurate copy of the purported receipt that Mr. Evans provided to you on April 3rd of 2024?
Yes, sir.
All right, we'll tender that as State's Exhibit B.
All right, do you have any objection to me using that document and making my decision on your case?
No, sir.
All right, then State's Exhibit B is tendered, I think I said State's Exhibit 1. State's Exhibit A is tendered and admitted. State's Exhibit B is tendered and admitted without objection.
All right, so Ms. Matthews, let's talk about State's Exhibit A. Excuse me. What is concerning about that doc? What brought that to your attention? Why you have concerns?
So I was actually in Superior Court earlier this year, and Bailiff Morse Pike came to me and he was concerned, and he's like, hey, I've got this person here and he's got us signing a community service log for your office and a community service log for the JAG probation office for the same hours. And I advised Mr. Pike that's absolutely not correct. He cannot get 2-for-1 credit for the same hours. So I had Mr. Pike provide me both logs so I could see the hours on both of them. And I personally went through, I can't control JAG. I have no access to that. So I only chose to address the log for my office. And I marked lines through all of the ones that appeared on both logs. So that way he would not get 2-for-1 credit. So if it didn't appear on both logs, then I left the hours on there. And then I instructed Mr. Pike to let Mr. Evans know that he was no longer allowed to do courthouse community service for my office, because there's no way that I can trust Mr. Evans is going to do it honestly, and there's no way for me to track without being able to see both logs at all times. So I told him for my office, he could not do community service in that manner anymore.
Okay, so Mr. Evans is on probation with sentence enforcement.
Mm-hmm.
He's on probation with JAG probation for a municipal court case.
That's correct.
And he had converted his fines for his state court case to community service hours?
That's correct.
Right. And he was allowed to do that community service by being present in the courtroom during it.
That's correct.
And so what you're saying is that he was doubling up his hours, getting credit for both JAG and municipal court and state court. So if he did 6 hours of courtroom time, he was claiming 6 hours in each court.
That's correct.
Okay. All right, are there any, and so his other community service issue was with this receipt?
Yes, sir.
All right, and that's what we've got as State's Exhibit B?
Yes, sir.
All right, can you explain to us why that's a concern to you?
Well, I already had the previous incident of the community service here where he wasn't being honest. And again, I was personally involved in that. So as soon as his officer brought this to me, this is just a note, and he's wanting me to give him credit for more community service based off of just a simple note. Again, the instructions are clear. It has to have a receipt. It has to have only the items being donated. Why Mr. Evans would think that I would be able to accept a note from someone, when we looked up the phone number provided on this letter, it does not go back to any Dollar General. So I can only assume that is a personal phone number. We did not attempt to verify these hours because I was not willing to accept it. Mr. Evans continues to try to turn in false information or tries to take advantage of the system. And to try to verify this and go behind each defendant, it is extremely time consuming. We've waived the fees for Mr. Evans, so all he has to do is his community service and report. And Mr. Evans is continuously trying to beat the system, and I just don't feel that he is a candidate for probation. I don't feel that I can trust him with anything that he chooses to turn into my office.
Okay, so as we stand here today, how many hours should Mr. Evans have completed of community service?
He should have turned in 48.
Okay. How many verified hours of community service has he actually turned in?
6.5.
Okay. And he's supposed to be doing 6 hours a week?
That's correct.
Okay, so he's failed to complete his 6 hours a week as directed?
That's correct.
All right, now, Mr. Evans is on a zero tolerance order with this court?
That's correct. He was revoked on his previous case, and part of that consent order placed him on zero tolerance for this case once it began.
So multiple revocations?
No, this is the first one for this case, but previous cases, yes.
Okay. So as a result of being revoked in previous cases, he began this case on zero tolerance?
That's correct, yes, sir.
And he's violated that based on his community service, or his lack of completing community service?
Yes, sir.
All right. And so you said he has a remaining time of 267 on this case? Is that correct?
Yes, sir.
Sorry, I'm jumping around. So if Mr. Evans were to be revoked this morning, is it your recommendation that we revoke the balance?
I would be willing to revoke 200 days and terminate this case. And if the court was willing for his second case to modify that case and allow me to convert that court fine on that case into credit for time served on this case, that way I know it's honestly and accurately done. He already had a non-report on that case, and allow him to go into non-report as long as he does not violate any new laws once released.
I don't have any more questions for Ms. Matthews.
Okay. You may ask Mr. Evans, Director Matthews, questions. This is not an opportunity to make a statement, but if you have questions that you would like to ask her, you may ask those questions at this time.
Yes, the phone number right here, that's the phone number they gave me to get to y'all to call them about the receipt.
All right, so we're gonna turn that into a question. Turn that into a question and answer it as best you can.
So we Googled the phone number provided on this one. Had it been for Family Dollar, then we were going to call that location. But once we Googled it, it came back with no history.
Well, that's the number they gave me. I mean, I don't know who number it is. That's the number she gave me to get to y'all. So I mean.
Okay, so that's a statement. This is your chance. So you're telling her information. I need you to ask
sir.
information. You can make a statement if you want to, but we'll cross that bridge when we get to it. I need you to ask any questions that you have.
No, I don't have it now.
Okay. All right, back to you, Mr. Shepherd. Any questions?
No, so I don't have any further questions for Ms. Matthews.
All right. You may call your next witness.
I'll call Bailiff Morris Pike.
Okay. I'm going to leave Director Matthews where she's at, and we'll just use where Williamson testified from the last case. So if y'all just use that.
Piper, can you grab Ms. Dobson? I think that's Ms. Dobson. Do you swear the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Can you state your name, please?
Morris Pike, he's bailiff hired by the Spalding County.
All right, and Mr. Pike, how long have you been employed as a bailiff?
6 years.
So have you previously had contact with Mr. Purnell Evans?
I have.
Is that in relation to your job as a bailiff?
It is.
All right, and was it related to his community service?
It was.
And as part of your role as a bailiff, you sign off on community service logs?
I do.
So when you were interacting with Mr. Evans about his community service log, was there something concerning to you about it?
It was.
And what was that?
He had me 2 logs, wanted me to sign off on 2 logs for his service as observation in court.
Okay. So when you say 2 logs, was it 2 logs for the same court or logs for separate courts?
The 2 logs for the same court.
Okay. Well, he was trying to get, was it a lot? But he was trying to get hours for 2 different courts?
He was trying to get hours for the same court.
Okay. And Why was that concerning to you?
Because I've never had it before. Usually it's one sheet for one position, and he was wanting to sign both sheets for just one position.
Okay. All right, and did you bring that to probation's attention?
I did.
All right, that's all the questions I have for Mr. Pike.
All right, Mr. Evans, if you want to ask this witness any questions, you may do so at this time.
No, sir.
No questions?
No, sir.
Okay, you may step down. Mr. Shepherd, you may call your next witness.
Judge, that's all the witnesses the state has on this.
Okay. All right, Mr. Evans, at this moment, the state has rested, which means that they're providing me all the evidence they intended to provide me on this case. You have a couple of options at this moment. You may choose to testify if you wish. However, if you choose to testify, you'll remain there at your seat. You'll testify using the microphone, and Mr. Shepherd will have an opportunity to ask you questions. And as long as those are appropriate questions, you will be required to answer those. If you choose to remain silent, I, of course, will not allow that silence to be held against you. And I'll make a decision based off of the evidence that's before me, plus any witnesses you may call. Do you understand that if you choose to remain silent, it won't be held against you, but if you choose to testify, you will be cross-examined?
Yes, sir.
All right. Do you have any questions about your decision whether or not to testify or remain silent?
Yes, sir.
What do you want to do?
I want to ask a question.
No, what?
Repeat it again for me, please.
Your two options are make a statement or remain silent.
Oh, yeah, I'll make a statement.
You'll make a statement, and you understand that Mr. Shepherd's going to be asking you questions.
Yes, sir.
All right. You're already under oath, and can I have your copies of the?
Yes, sir.
All right, Mr. Evans, I now have copies of these two exhibits in front of me. The floor is yours. Just talk nice and slow, lean into the microphone so that the court reporter can make a good record of what we're talking about here.
Okay. I didn't know I couldn't. I thought I could do my two commuter service at the same time. I didn't know I couldn't. I mean, it wasn't my fault, so I mean, I didn't know that I couldn't. So
Okay.
it wasn't that I was trying to get over or nothing like that. I didn't know. So,
Okay. And that's as far as the log sheet here that I'm, State's Exhibit A.
yes, sir.
Okay.
And I don't have a problem about doing my community service or nothing like that. I've been trying to do my community service. I've been turning in stuff like that, but
Okay.
yeah, I'm on two community service at the same time. It's been a problem with me about that. So, I mean, I would like to ask you, could you take me off the community service? I would like to pay some money every month, but a little money every month.
I'm losing you. You've moved away from the mic and you've sped up. So
Yes.
slow down and stay with the mic.
Okay, I would like to ask you to take me off the community service, I signed up for the community service. So if you could take me off the community service, I would like to pay some money every month.
Okay. Am I correct that you also asked for all of your supervision fees to be waived? The
Yes.
monthly, and we waived that, correct?
Yes.
So you have no money currently due to the court? Nothing at all? Is that correct? No money, you don't owe us any money that I'm aware of?
No.
Okay, that's it. I just want to make sure of that. So, okay, what else do you want me to know?
I just wanted to know that. Just want to tell you that I would like to pay some money every month. I just want to be off community service, so I won't have to have no problem with it.
Okay. All right, thank you for that. Anything else you want me to know?
No, sir.
All right, Mr. Shepherd, you may cross.
So you asked for have your fines converted to community service, correct?
Right.
Okay. And you just testified a second ago that you were in fact having logs signed for two courts at the same time.
Yes, but I didn't know that I couldn't do that. I didn't know that.
You didn't know that you couldn't claim hours for multiple courts at
No.
the same time?
Oh.
You don't see a problem with doing that?
Well, like I said, I didn't know that I couldn't turn both sheets at the same time. I didn't know that.
So had it been a fine, because you had your fines for both courts converted to community service, so had you owed a $100 fine to Spalding and $100 to Griffin Municipal, you thought it would have been fine just pay the $100 to Spalding? Because that's what you're doing, right?
Yes.
Okay, you think you don't see a problem with that?
No.
Okay. All right.
All right. Anything else, Mr. Evans, you want me to know?
No, sir.
All right. Any witnesses you wish to call or anything else?
No, sir.
All right, Mr. Shepherd, he's rested. Do you have any other witnesses to call?
No, sir, Judge.
All right, then the evidence is closed. All right, so it took me a minute to piece together Mr. Evans's procedural history, but I have it now in front of me. And the short answer is that Mr. Evans has created a significant amount of, frankly, confusion, and it seems to me that we worked pretty hard to make this easier on Mr. Evans, but it keeps getting more and more confusing. So I need to point out that I had already made the conclusion that Mr. Shepherd made in his cross-examination questions, which is that these hours that he was double dipping on are converted hours, meaning that he owed money to Spalding County and that he took that money, converted it into community service work hours, and then was going to work it off, meaning he was not going to pay any money to Spalding County, because I also have my order on the screen right here saying that he asked for and got all of his supervision fees waived, which we do very open-handedly here. That's not a secret. And so that means that he didn't owe any supervision fees. He didn't owe any more fine. And this is one of those moments where I'm just going to say it, and everybody knows it because I say it all the time. He had one job, do community service work. And instead of doing it in a normal way, he decided to try to double dip. And I did not hear any testimony anywhere that he asked anyone at JAG or anyone at Sentence Enforcement if what he was doing was acceptable. He assumed it was acceptable until it was not. And he's already testified that he thinks that this was not his fault and that he was not aware that this was an issue. But I'm going to go ahead and call it what it is: stealing. He was stealing money from Spalding County by converting his fines into community service work and then scheming so that they could be split in half and hidden. And the only reason we caught it was because Morris Pike is very good at what he does, are all of our bailiffs, and figured out that this was a scheme. Now, if this was the only thing at the table, I would kind of maybe go okay. But this is what seals the cake, State's Exhibit B, which is Director Matthews is well aware that I have been a very reluctant approver of this program that I think is amazing. And I want to say that out loud. This program that provides items to Promise Place is a wonderful program that scares me to death because of people like Mr. Evans. Mr. Evans is exactly who I am scared of in approving this thing. And every time we have to deal with one of these, it makes me go, this program is amazing. It provides food and diapers to Promise Place, but then people like Mr. Evans come in and ruin it for everyone else by scheming and trying to, I mean, it's only for $33. I don't want your opinion. You need to keep your mouth shut. I gave you your hearing. Do not interrupt me. Do not interrupt me again.
Sir.
I was trying to ignore the fact that you're interrupting me, but if you do it again, we're going to have a major, major, major problem. And instead of bringing in the receipt, which it's a very simple system that Director Matthews has come up with, he comes in with this handwritten note that has a number on it that doesn't go back to anywhere, according to the testimony today. And I don't know if this number goes anywhere, and I don't care enough to call. But the fact is that even this second round, it's a scheme. Like, it's one of those things of you get one coincidence before, and everybody gets one, and then a lot of people can get two. But man, as soon as you get to three, like, I'm done. There's no coincidence here. It's a scheme. It's a plan. It's an organized event. And that's exactly what I see here. So I don't have any hesitation saying these are fraudulent, false, intentionally misleading, intentionally stealing items. And I find that he's committed a felony false information to a government agency. Put him in cuffs. Your opinion on my decision is irrelevant to me. So, Mr. Evans, you had a very simple thing to do. One job. Do your community service work without causing issues. And I am very comfortable with my decision. I have no hesitations on what I've just done. And I am revoking the balance, because instead of accepting what was on the table, he denied it. So whatever it is you were going to give him credit for time served on, you can mark that out, just revoke the balance. I'm revoking the balance of the next case as well. So whatever they offered, I'm not doing it. I'm not doing it. I want to send a very clear message that if you lie to me like you just did, I'm taking the balance. So that's it. No, I don't want your opinion. I gave you your hearing, Mr. Evans. I gave you a full hearing. I gave you a full hearing, Mr. Evans. You have 30 days from today to appeal my decision. Does he have any other cases with me?
Not other than 22 SR 637 that you just.
I'm revoking that one too.
Yes,
I'm revoking all of it. Mr. Evans, you go tell whoever you want to tell whatever it is you're going to say, but not me. Step on back. Where is states A and B, the originals? Do I have that
I
here?
think you have it.
Okay, so we'll scan these in.
Do you need me to scan those, Judge?
Yes, that would be wonderful.
The court can have those. We brought copies, so we have ours still in our
So
office.
if you'll just scan those in and
I-
email them to Ms.
and that
Kathy.
warrant,
I think I gave you something that, oh, I wasn't supposed to give you that. No, I think I did right here. Go ahead. Yep. There it is.
Here's the warrant.
Okay.
I just need to keep my office.
All right, what else are y'all here on?
I believe
This
that's it, yeah. Marty, do you need me on any of those?
I don't, that would be,
Yeah, I keep forgetting.
that's okay. He was asking if you had anything on docs,
On what?
order or anything.
Yeah, I passed it that way.
Yes.
And I've written by my calendar so that I'll remember Purnell Evans, cheater, revoked the balance. Because
Thank you, Morris.
I can't deal with that. Like, I have a whole lot of things I'm willing to move on. Lying to me is not one. Okay, we ready to go through the last couple of folks here?
Do you want me to see if we can get him to sign, or do you just want me to assume refuse?
Yeah, see if he signs it. That would be very helpful if he refuses to sign it.
Well, if y'all don't need us, we'd be excused.
No, that's it.
Revocation.
Hey bailiffs, will y'all see if he'll sign this document? If he refuses to sign it, don't worry about it, just write refuse to sign.
Yes, sir.
You ready? All right, so let's knock this last couple of cases out. All right, for those of you here, I'm gonna call you up. Y'all's cases should go a whole lot smoother than the ones ahead of you. So let's start with Alvin Capps. All right, raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. Mr. Capps, state your full name for me.
Alvin Moore Capps, third.
All right, now I have a lot of Capps. I have a whole lot of Alvin Ward Capps in my system. What is your birthday?
5/28/93.
All right, and what's the last four of your social?
1031.
Okay, and you are the third.
Yes, sir.
Wait, what's your social again?
The last four is 1031.
No, you're gonna have to give me the whole thing. I have something different. What's your whole social?
255-87-1031.
1031. And you said 5/28/93?
Yes, sir.
Okay. All right, well, I'll get that cleaned up later.
I also have Junior in my system, if you wanted to confirm any of that.
Is Junior your dad?
Yes, sir.
What's his birthday?
April 14th, 1960.
Last four of his social is 3347.
That's what I have on his, is 3347. So I've cross-merged them, so I just need to unmerge. Okay, all right, that tells me what to do. All right, Mr. Capps, what's gonna happen next is, you have the right to have an attorney represent you. You're here representing yourself. Is that okay with you?
Yes, sir.
And what's going to happen is Director Matthews is going to read out both the allegations and what the state's recommendation is. And then I'll ask you two questions. Do you admit to the violations, and is that recommendation acceptable? If you say yes and yes, I'll very likely follow the recommendation. If you say no, then obviously we'll dig in, figure it out, and go from there. Okay?
Yes.
You ready?
Yes, sir.
All right, floor's yours.
Judge, on 22 SR 0988, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant's failed to report to probation as directed, having missed 3 of 6 scheduled appointments. The defendant's failed to pay the court fine and fees as ordered, or utilize community service work in lieu of the court fine, being in arrears $250. The recommendation on this case is for him to report as directed payments of 92 biweekly, zero tolerance for 90 days. His license would be due by July 23rd of 2024, or he would need to turn in a detailed suspension report. His next report date is in person on April 24th between the hours of 1 and 5.
All right, 2 questions. Do you admit to the violations?
Yes, sir.
And is that recommendation acceptable?
Yes, sir.
All right, then I'm going to find that with your admission that there's enough for me to revoke your probation, I'm going to find that with you accepting the recommendation that that is the proper result of this hearing with that admission, and I'm going to make it the order of the court. So, any questions for me?
Yes, sir. Well, about my license, they're saying I gotta have a ignition interlock. I was gonna see if there's a way I can try to get that waived or.
Is that me? Am I the one who has that hold on you?
This is a hit and run, reckless, and a suspended license charge, and that's all I have in my office
All
currently.
right, so go to the clerk's office sometime in the next day or so. Ask to be put down for a Thursday hearing with me. You're going to come back with that suspension detail report, which you needed anyway, and your driver's history, and let me take a look at it in the courtroom, and we'll go from there.
Okay.
If I can grant you the interlock, and if it's all lined up, I'll grant it. But if not, we'll at least get a plan of action. Okay?
Yes, sir. Thank you.
You can also just take it to them, and they will also help you with it. So if you want to start with them, that's probably your best course of action. Actually, now that I've said that out loud, go get that report, go show it to them first, and then come to me second.
Okay.
All right, thank you.
Yes, sir.
All right, they have got to bring the inmates across, and I can't do that while I'm sitting right here. So I'm gonna step off the bench just for like 60 seconds, just to let them come across. And as soon as they knock on my door, I'll come back and we'll knock y'all's cases out. So I'm not disappearing back into the
Yes, sir.
All right, floor's yours.
Judge, on 22 SR 0515, the defendant is alleged to fail to provide proof of attending and completing family violence intervention program as ordered by the court. The recommendation on this case is for him to report as directed, payments of $73 biweekly. I want to be cautious, that's only referencing this case. He has a concurrent case as well, so the payment of 73 is only for this case. To enroll in family violence intervention program within 30 days, to attend weekly without interruption, 0 tolerance for the duration of active probation. His next report date would be in person on April 24th between the hours of 1 and 5.
Okay. 2 questions. Number 1, do you admit to the violation?
Yes, sir.
And is that acceptable to you, the recommendation?
Yes, it's just, see, with my work, my boss had wanted me out of jail, and he's not letting me get off in time to, do the class, which is at 5:30, I believe, on Mondays.
Is there another center that offers it at a different time that you could use?
I've been trying to find one that's on, Saturday, but I can't find one so far.
Judge, just so the court's aware, on our website, there's locations on there that are virtual. He wouldn't even have to physically go onto locations that are approved, so.
Okay. Does that work for you?
Yes.
Okay. Well, let's do that then. And I see these 2 are concurrent. Now listen, hear me very carefully say what I'm about to say. So I could, if you wanted, move one of these cases to go after the other. But you are 100% the decision maker on that. If you think that would that give him more room?
It would give him more time. It would possibly give him the ability, if he ran into an instance of some issue happening with the family violence, where we would only be able to look at jail time. We would have another case that we could possibly modify with his permission, if we ran into additional errors later in the game. Otherwise, we have 224 days remaining right now. This class takes 180 days if he goes every single week.
Okay.
So he doesn't have much room.
So do you get what I'm saying? Like,
Yes.
I knew it took 6 months to do this class, and I knew you only had 224 days left. So hear me say, the law, Georgia law, does not allow me to just go, I'm going to rearrange your cases and put one after the other, because right now they're running together.
Okay.
But sometimes when folks end up in a situation like yours, where we're trying to come up with a solution that doesn't involve jail time, I will simply throw that out there as an idea. But I want to make certain you hear me say that I will never impose that over your objection. That is something that we would only do if you thought it was in your best interest to move the 2 cases so that they're back to back, giving you more time. And then I would make the second one terminate upon completion.
Okay.
So that if you needed some time into the second one, you could, but it would still close the moment you got there. So
Okay.
I'm just letting you know that's an option, but there is absolutely 0 pressure behind that. I want to be very, very clear with that. That I'm just trying to figure out, a solution that gives you some room to breathe. So, do you want to talk about that, or you want to think about it, or?
So it would give me more time though, having them back to back?
Yes, and the second one would be terminate upon completion, so that if you didn't need it, it would go away. But if you did need it, you could move out into it a little bit. So that way I don't have to think about jail time if something happens and we have to restart.
Okay. Okay, I'll go with that.
Okay, and again, you understand the law does not let me do that without your permission.
Yes.
Okay. Well, let's do that then. That'll move it. And this is the reason why we don't do these anymore concurrent, because it doesn't work. So, okay. Well, Mr. Mitchell, I'm going to put that I think I stressed sufficiently to you that I would never do this without your permission, and that there's no scenario where I ever could order it over your objection. But we think this will work. We'll make the second one. We'll make the other case terminate upon completion.
Okay.
And that way, if you get there and you don't need it, it's not there.
Okay.
Okay. All right. Does that work?
Yes, sir.
Okay. And then obviously the family violence will carry through to the next one. Okay. Perfect.
All right.
So she'll send, I'll sign orders on those, get you to sign them as well, saying you're okay with it. Oh, it's right here. So perfect. All
I'll
right.
get his signature on that, and I'll prepare a separate order for that case for you to sign to E5.
Correct. Okay. Are you ready?
Nakira Smith.
Actually, let's do the last lady.
I
Hold on,
couldn't
y'all.
remember which one.
Yeah, let's do Thorpe because she's here.
Okay. I was trying to remember.
Yeah, I knew. I caught that pause. We were trying to remember if you were Smith or Thorpe.
Oh.
And you're Thorpe.
Yes.
All right. All right, raise your right hand for me. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. So take your hand down, state your full name for me.
Makiba Thorpe.
Ms. Thorpe, you're here today on 23 SR 0609 because your sentence enforcement supervisor has filed paperwork with me alleging that you're out of compliance with your probation. Do you understand what you're doing here today?
Yes, sir.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yeah.
All right. And are you ready to go forward?
Yes.
Okay. All right. Floor's yours.
Judge, on 23 SR 609, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant did test positive for marijuana on or about March 13th, 2024 at the Spalding County Sentence Enforcement Office. The recommendation on this case is 2 weekends in jail on May 3rd at 6 p.m. and May 10th at 6 p.m. to report to probation as directed, payments of $30 bi-weekly, community service at 8 hours a week, zero tolerance for 120 days. A new substance abuse evaluation would be due within 30 days and follow any recommendation. The next report date would be in person on April 24th between the hours of 1 and 5.
Okay. So 2 questions. Number 1, do you admit to the violation?
Yes.
And is that recommendation acceptable?
Um.
Oh, you dropped something. Something fell out of your pocket there. Behind you. Look back.
But yes. It sounds acceptable, but the jail time. What was the jail time?
So when I have a positive marijuana screen, my starting position is 2 weekends in the jail because I want to
Okay.
get your attention, not
Right.
you specifically, but just generally.
Right.
Now, whether you serve those 2 weekends, that's up to the jail. They'll either let you in or turn you away at the door. I don't have any interest in that. My job is to put that on paper.
Okay.
So you may end up serving the full 48. I don't know. But the point is that my position on it is that if I have an illegal substance in somebody's body that's not supposed to be there while they're on probation with me, that I need to start with 2 weekends.
Yes, I understand that.
So I understand you don't love that, and I respect the fact that you don't love that. And frankly, I did it because you don't love that.
It makes sense. I just had a question on what you think about the low THC oil in Georgia.
So if you're interested in that, the way it will work is you will, well, that issue, do you have that? You have a card?
I plan on getting one because
Oh.
it goes with my I take medication and I'm trying to go the other route than.
Okay. Well, the short answer is then at this point, since you don't have it now, it doesn't change my
Right.
position, but go get it.
Yeah.
Goodness, go get it. Because
Okay.
obviously, plenty of people come in here with prescription drugs that
They don't have.
they don't have a prescription for, and
Mhm.
it's the exact same thing. So
Right.
if you have a prescription for it, then we're in much better position.
Okay, I just had to ask
Yeah,
about
you just
that.
need to get some movement on that. So, okay,
Okay.
well, I'm gonna follow the recommendation. So, and I'm telling you, go get your prescription card
I am.
so that we don't have to have this conversation.
Right.
And obviously, once you get the card, do not come in here with a high reading because I have people that come in and do that, and they're like, "I have this card," and I'm like, "No, that does not equal that amount in the testing." All right, last person out in the hall, you got it. Okay.
Mark's gonna get it.
Thank you. All right, I'll stop.